Yeah, welcome to the No State Project. You're listening to 3 hours of anarchy radio right here on the No State Project. We are live from the fortified compound in Mesa, Arizona. Glad to be with you here. Glad everyone's tuning in to the big show today. And if you would like to join me on the big show, you may do so at 218-632-9399. 218-632-9399. Skype is also connect with me during the break. Instant message me at Frank Rizzo 3. That's Frank Rizzo with the number 3. And for the 218-632-9399, the passcode, if needed, is 2020 with the pound sign or the hash tag. And I got to remind everybody, like I mentioned on episode 25 the other day. In fact, it's actually July 15th, I should say that. July 15th, 2017. We should be live again this Wednesday for episode 26. And so before that, I'm hoping to get to Desert Eagle on Main Street in Mesa at around 6 o'clock for an open mic night blues jam. So if you are in the valley, check out, it's right near Milano's Music. It's right there in downtown Mesa on Main Street, the north side of the street. And if you're there around, anywhere around 6 o'clock, you're probably going to hear it. So I definitely want to check that out. And I hope to see anybody local there. Speaking of, remember we got the whole Jackalope Freedom Fest coming up. Today's the 15th, so we got 16 days. So just about 2 weeks that's going to start in Bacchus Meadow. It's northeast of Phoenix, about 2 hours. And absolutely beautiful. Hope to see you guys there. It's about anarchy. Anarchy being an absence of rulers. Not an absence of rules. See, what we have now is two sets of rules. Where, for most of us, it is wrong to lie, steal, kill, cheat people. To use aggression. There's a double standard that it's okay if you force people to pay you and call yourself a government. Then it's it's okay. But as anarchists, we reject that the basic principle of do no harm applies to everyone, not just to the majority, not just to the plebes. So I've been getting this a lot. Oh, and I want to mention I did finally get episode. I was just talking about. I finally got episode 25 of and we say episode 25 because that's the Wednesday commercial-free edition. So basically, an hour commercial-free is about half of the content that we get during these broadcasts, which are 3 hours long. But since we don't have the commercials, we get a lot more content. So I did get that video up. I still can't believe that it wasn't until I was talking about her during a live broadcast that I finally put together about Patricia Starr with Patrick Starr. So you can go to my YouTube channel and check that out. I'll have that embedded in Mark Stevens in the page on markstevens.net later today, but you can still go and check that out at my No State Project YouTube channel, which we are less than 100 subs away from the getting 9,000 subs. So if you're not subbed, I know I don't do that in the videos. I hate that. Like and subscribe. Yeah, we're adults. We know if we want to do that, we will. But let's see what we could do about getting to 9,000 this week. We should be able to do that. I've been getting this a lot, and I guess it's great that there's new people, and so don't take this the wrong way. It's just I'm getting these questions that I guess people are, because they're new, they're not hearing or they're not going through the archives, they're not going through the articles or the videos that I put up, but it seems to be and I guess this is a legitimate concern, but, we cover this subject quite a bit. And by quite a bit, I mean every single show. Some people new are asking me, about how do we go about showing that we're right, that the laws don't apply. I don't want to feel, and I don't want to feel silly going into court and just saying, "Hey, your laws don't apply to me." Nobody's claiming that. Nobody is claiming that. And that's a typical thing with the trolls that does, well, Mark just says he's an idiot. He says the laws don't apply to him. If I'm making an affirmative statement like that, you got to get it right. If the statement that we make, the position is the proposition based on a number of irrefutable premises that logically follow, wind up with the statement, the proposition being there's no evidence that these rules apply to anyone. Okay, and this is not a matter of, oh, Marc's just an anarchist, he's just some kind of narcissist douchebag. He thinks he's special, the laws don't apply to him. No, there's no evidence they apply to anyone. I'm not setting myself out. It's not about me. What a stupid criticism. So that's how you know you've got somebody. You have to start launching into ad hominems. Well, I can't actually attack your position, so I'll either misrepresent it or just call you a douche. I may, in fact, be a douchebag. I might just be some schmuck from Long Island. But I tell you, nobody can tear apart and show where my position is wrong. Nobody can overcome the evidence. Nobody's able to show a justification to show that it's not a double standard, that my taking people's money by force, perfect strangers, my forcing strangers to give me money, that's always criminal. And they can't possibly demonstrate how there's no logical, rational position to overcome that, to say that it's not a double standard when people call themselves government and do it. Every single thing is refuted. All of it is refuted. So keep in mind, I've never said, go into court and tell them your laws don't apply. It's not a defense. I've never said that. And those who claim that I did, and they're on both sides of the fence here, whether anarchist or not, my position has been taken wildly out of context. It's been strawman to death, even by hosts on this network. Daryl Perry, I don't know if he's ever corrected himself. I never got around to calling into the show Free Talk Live and correcting him. But even he, as an anarchist or voluntarist, can't get my position correct. So that's why we're going to just keep saying it until, at least the honest people get it right. Now, I'm sure Daryl Perry, if I was to call, and he would make a correction on the air. But one of these days I'll get around to doing that. But the position is, or the defense is, to just ask questions. It is to take someone's claim, assume it is wrong until the evidence and the rationale backing it up is on the table. So the position is that the prosecution, my accuser, doesn't have any evidence to support his claim. Now, that claim just happens to be the one that we attack the most, is the one that's the foundation. We're striking at the root, or striking at the root, depending on where you're listening. We have a very limited amount of time to make these challenges, so you better make it count. So go for the foundation. Knock the foundation out. Destroy the showing of relevance that they have. Relevance, of course, being any tendency to prove a proposition. So if you can destroy the relevancy of all the other crap, it saves you some time. So keep in mind, the position is not, your laws don't apply to me. No, the position is quite different. You don't have any evidence to support your claim that your rules do apply. Quite a different position to be in. It keeps the burden of proof on the accuser. We'll discuss this and more when we get back here on the No State Project. Don't go away. Welcome back to the No State Project Live this July 15, 2017, here on the Liberty Radio Network, LRN.FM. I just want to apologize. I don't know if it was because I didn't pick up the calls for the first segment, but if you're listening, please call back if you want to join the show. The point, I never take a call or start with a guest in the first segment. The first segment is just too short. In fact, that's the thing. I think the first and last segment of every hour, because of news and whatnot and stuff on the network, are a lot shorter segments. And I don't like coming up and almost immediately going to commercial when I've got a caller on. I just can't stand the commercials and having to have a break in the flow of the conversation. So that's why I don't do that. So if you're listening and you were on the line before, give a call back. I will be taking the calls. 218-632-9399. 218-632-9399. And the Skype, and the passcode is 2020 with the pound sign. And Skype is Frank Rizzo 3, but instant message me first before. You don't just call during a live segment like this over here. We got plenty of commercial breaks. We have 11 altogether, or 12. So, well, we'll say 11 so we can get you on. So please keep that in mind if you want to join me on the Skype. So what I'm talking about, getting the position right. Understanding the basic tactic so that you don't... Look, and I am not going to kid anybody out there. You go in to any bureaucrat or you go into to the average person and you start questioning sacred cows, they're going to, especially if you're in court, they are going to do what they can to gaslight you so you will feel stupid. So this thing that I don't want to feel stupid when I go in there, that they're going to get you to try to feel stupid. That's what people will do when they have no evidence to support their claims. Are you seriously questioning whether the laws apply to you? I'm questioning your claim that they do. Now, do you have the proof? And this is the same no matter where we are. So the difference is some of the terminology is like if you're in England, some of the terminology is a little different. We don't file a motion to dismiss. We don't call it that. We call it an application to dismiss. Instead of a pretrial conference, you have a case management conference. But it's all really the same thing. It all stems from the same claim. And that claim is always based on your physical location unless you're talking about the feds. But even that started, well, then again, see, the feds think that their rules are so magical and so powerful. They apply on every square inch of the earth. Every square inch of the earth. It's not one of these things where 200 years ago, if you get into the ocean, it's no man's land. No, they think that their rules apply. That a magical piece of paper from 1787, okay, gives them some kind of magical godlike quality that their rules apply to every square inch of the earth. No other criminal organization calling themselves a government actually claims that. Not that I know of. But for the most part, it's always based on your physical location. So in England, the same thing. You're physically in England, our magical rules apply. End of discussion. So we want to know if they have proof of that. And yes, we know they're going to mock. Go to my YouTube channel and see there's a handful of trolls that can't help themselves. That I'm an idiot because I would add, well, Mark, you're an idiot. There's something psychologically wrong in your head. The wiring in your brain is really screwed. It's like you have a brain injury. You keep insisting that law requires evidence to show that it applies. When the law says it doesn't, it's not in the law. No. We expect the gaslighting when you go in and you're challenging these sacred cows. If when you start challenging something that people have taken for granted, or they have a huge emotional or an economic vested interest in there, of course they're going to mock you. So that's why we role play and we prep so that we're aware of this. We know the tactics that they're going to use. It's going to be distraction. It's going to be a straw man. It's going to be saying anything to avoid just putting the evidence on the table or admitting they don't have it. So we're staying rooted in logic. Something, a basic principle of thought, non-contradictory identification. Everything that we have that has increased our way of life, our standard of living, has come from a rigid adherence to basically the scientific principle, and that there has to be evidence. There has to be evidence of causation. That things are not true just because someone said so. You do not you can't listen to me doing this live in Australia, mate, based on issues of faith that we're just going to, say that this is true and it's going to magically be that way. No. It's a reason why we are where we are, because because at least enough people have relied on logic, on reason, to advance us socially and not so much socially, but economically or definitely with technology. And we can have stupid discussions about whether the earth is flat or not, because people used reason, because they used math 2,000 years ago, and through their observation were able to prove that it's not flat. But for some reason, there are people that want you to believe that reason and logic have no business in court. In fact, if you read U.S. v. Olson, where Judge Kaczynski gave in that decision, I believe as I was reading it yesterday, he even claims that issues raised were red herrings. Red herring is something that's used in basic logic. I thought it had no business in court, and yet it's an appellate court decision. The people who tell you that basic principles of logic, under whatever verbiage, do not apply in court are not being honest. That's in or out of court. But we'll be back with your calls in just a moment, so don't go away. Welcome back to the No State Project. I'm Marc Stevens. The website, of course, marcstevens.net. Remember, you can get Government Indicted as an ebook, which contains a whole model for what we discuss on the show twice a week, most weeks, how to effectively defend yourself. And we'll get into that a little bit more, continue where I was talking about. We'll get to, I'm going to actually read a little bit, because it's been a few years, directly from the Olson case that I mentioned before. The red herring was mentioned in another case. I should have made a copy of that, but I don't remember it off the top of my head. But those things are mentioned all the time. Anyone who says that the basic underlying principle of logic has no place in court is just dead wrong. I mean, you have to have a logical argument. I mean, you can't just be a non sequitur. I mean, that's what the whole word frivolous really comes down to, a position that is not only wrong, but it is so wrong it requires no demonstration, because it doesn't make any sense. It's not supported by logic. It's not rational. That's why you can have an argument that is considered wrong and one that is frivolous. You can't be in the mindset like these scumbag U.S. attorneys and prosecutors that think that everyone who disagrees with you or has an opposing argument is frivolous. It's the only freaking word these idiots know. Oh, you disagree with me? Frivolous. Sovereign citizen, frivolous. Fungal. I'm getting my Sicilian up early on this show. He's been on his show before. I think he's got an update for us. Patriot 1 from Florida. What do you got for us today?
Hey, Mark. Thanks for letting me on. I wanted to go over, I didn't get his traffic citation, but a good friend of mine did. And I wanted to go over just two parts of what we got with the citation, what we got in the mail afterwards. And you could plead guilty, make payable, pay to the make the check payable to the circuit court clerk noted below. So I suppose if I want to pay this off, I got to write a check out to Roger Schott, which would be the circuit court clerk. That just seems it doesn't seem proper. You know what I'm saying? Why would I make a check payable for a fine to a court clerk? Is he cashing in himself? But anywho,
well, I imagine since it's done as the court clerk, he's doing it in his capacity of the clerk to collect, the booty, the ill-gotten booty for, on behalf of his master, the abstraction called the state. So I would imagine if it went to his personal account, then yes, they would probably have him arrested and incarcerated for embezzlement. They don't like when their own steal from their own. Court clerk is just a lower level, grunt.
But the way I read it, this instruction page forces me to put things together where they belong instead of saying straight out, make it to the circuit court clerk, Roger Schott, all in one sentence. It's all separated. So the accused is forced to piece things together to figure out how it works. That's what I'm trying to say.
Oh, yeah, that might be true. I think the real problem with these things is the false choice that they give you, that they say that you either pay or request a hearing to contest it. And I think
this is either pay. This is pay or appear.
Pay or appear. Or okay, that's the same. Yeah, I disagree with that. And yes, I'm going to inject logic here. That's a false choice, that there are more options available, which include, of course, a motion to dismiss for lack of evidence proving jurisdiction. They like to leave that part out. That, I think, is more of an issue.
I would like to do that, but the accused does not, because it's 1,000 miles away. It'll cost us 10 times nearly to do this than to just pay it.
Wow.
But okay, so the citation has one number on it, a control number. That's it. So we get a letter from the J.L. Albright, the Laurel County attorney, and he's got a case number and citation number that's completely different and doesn't match any numbers whatsoever on the citation. So I'm wondering, on that, has there been something filed in the court? Would that indicate something has been filed with the court?
If you have if you have a docket number or case number as opposed to just a citation number, then yes, the road pirate who gave him the ticket has gone through and filed in court.
Okay, so should they have sent us a copy of whatever's been filed with the court to give us a process notice or anything like that?
I thought you had that, but you had the citation.
We got the citation, but we don't have whatever is listed under this new case number that was filed with the court. So there's no indication that is it the same or any different. Because the numbers don't match.
Well, that's, again, the numbers don't match because they're not going to be based off the citation number. So it doesn't, to me, I get that he's away. I would still file the motion to dismiss in the Brady request, even if I was planning to ultimately pay it. It doesn't cost a lot to file the motion. You just making a few copies and mailing it to the police officer who wrote the ticket and to the clerk of the court. You get 2 copies.
Right. We're going to have to fish out the address for the police officer and everything. On the citation, we get his last name and first initial printed by the computer, but not signed by the officer. So that's kind of weird there. And continuing, but I'm going to call him and ask him. We need a copy of the case that's been filed under this new number, and see what it is. There's got to be some kind of facts and evidence and witnesses on it.
Well, they're supposed to be. They're supposed to be, but chances are all that they did was file the citation with the court, and the clerk processes that and gives it a court docket number. That's probably what happened. That's the most likely thing to happen. As far as getting, if there are notes of the police officer, that's why we do the discovery request, to get a copy of what else besides the complaint has been filed, if anything. And if it's just traffic, more than likely it's nothing more than a complaint. So that while I agree with you that there's supposed to be factual allegations listed in there, they're not going to be.
Right. Now, if you read the rules of court, for me to file, say, a claim against you, I would have to have facts, evidence, witnesses. I'd have to invoke the jurisdiction of the court. I'd have to have all these things in order for me to even get to the court.
Well, you're talking about literally two sets of rules, though, that you're talking about. There are criminal rules, and then if you want to go after me for something, that would be under the civil rules. So they have ruled, again, it's their courts, and they're going to always go back, for their team. They have ruled that the allegations, it's very sparse, that their allegations need to be, for there to be, in their eyes, a valid traffic citation. Very sparse. And that's why we challenge it the way we do. Because in a broader context, it's still an adversary proceeding. It's still an adversary system. And to have true adversaries, you have to have certain things. Injuria et damnum. You have to have a legal injury, and you have to have damage. Now, even in a criminal context, those are it's still a case. You have to have the injury and damage, but they use different verbiage. So they'll say corpus delicti, which the corpus delicti is the act and the result. The act is the legal injury, and the result is the damage. It's all the same thing. So they still are supposed to have that, which is why they fight us so hard when we start asking questions, trying to plead guilty, or asking them questions, whether it's civil or criminal, or what the burden of proof is. They don't want to tell you. So we cut them off at the knees. Well, hold on. We're up against the break. We'll talk more about this when we get back. You're listening to the No State Project here on LRN.FM, talking with Patriot One in Florida, and maybe some shenanigans with a ticket. And we'll get into that more when we get back. Do not go away. Welcome back to the No State Project here on the Liberty Radio Network, LRN.FM. You can get the podcast, of course, at markstevens.net. And the latest live episode from the Wednesday edition, episode 25, is now available on my YouTube channel. And we should get that embedded in markstevens.net today. Because I have pictures. I have pictures of, I think, pretty much every bureaucrat that I mentioned in the videos. So check it out. markstevens.net, and my YouTube channel is No State Project. So let's go back to Patriot One in Florida. All right, so where were you? Where did we leave off?
We're working on the citation. I wanted to get to my last point of the fraud that's going on, I believe, because on the citation it offers state traffic school for a court cost and an additional fee for the school.
Sure.
So we get a letter from the Laurel County attorney offering us to attend the county attorney traffic safety program for $275. He recommends that the court be allowed to enter, or that if we attend or participate in this program, and on his form it says this is not state traffic school. So it's a completely different thing. But he recommends that if we do this program, that they will dismiss the citation without prejudice.
Well, they dismiss it also if you go to the state traffic school. That's kind of the condition. Right. They drop it for you going to school, and there's no points on your record. That's the reason why it's such an attractive option for people in traffic, because they can spend a few $100 on that stupid class, but it saves them thousands on insurance fees. So, wow, the guy's got his own private school?
Yeah, the Laurel County Attorney's Traffic Safety Program is what they call it. It's not the same as the state traffic school. It's the Laurel County's program. So you can do the state program at request of the clerk, or you can do the Laurel County Attorney's program just by filling out a form and signing on to the computer and sending them $275. It doesn't say that this program eliminates court costs or anything else, I suppose, but
well, neither one of them do. There are times where in Florida and some other places that even if the ticket is thrown out for lack of evidence, they still want to charge you court fees. The court fees are always there in some places, whether you win or not, whether you enter a plea of, and do like you're saying.
Because I was thinking of just calling this county attorney and saying, dismiss the case and we'll pay the court costs. Or ask them, if I do your state program, does that eliminate the court cost and the fine? And it's just, well, it says dismiss without prejudice. So, there's so many questions here, but basically it boils down to, which one of these programs are you going to purchase from us?
Yeah.
Or are you going to fight us? And also, when you make payment to the county attorney's program, you make the money order payable to a third party, Advent Financial Systems, at a PO box. So this has just got to be the most laundering, fraud, deception. It's just amazing.
It might be. I would still test the water by filing the motion I'd mail it in, see what kind of response. And if anything, say, look, I'll go with the state traffic court to avoid trial, since But hey, even that might require your physical presence, though, or is it an online program?
Well, it doesn't say if the state's online, but it does say the county attorney's program is online and is not available to those carrying a commercial driver's license for the county attorney's program. And
is that the situation here?
That is correct, yes.
Oh, yeah, I'd file the motion. Well, yes, that's... I see. He can't afford to lose. If he loses, it's his job.
It's so far away. That's the problem.
Yeah, it sucks to bite the bullet on that one and probably just go, do more investigation, like you're saying, and find out what is entailed to make this go away either way, whether it's the county program or whether it's the state one.
Yeah, because I could probably call the county attorney and ask him a few questions just put the Brady request in front of me and just start asking him questions and see where he's willing to go. Maybe he's willing to go, well, we'll drop it and fine you court costs.
Well, I think it's always worth it to try to plead guilty and ask the questions. You get some leverage on the guy. Maybe get an even better deal.
Yeah. But I wanted people to know, because I know they can get questions and you get all this paperwork, and we don't do this for a living. We're plumbers, electricians, fellers, whatever we do for a living. And that's what makes it so difficult.
They definitely have the process. They definitely make it more convoluted and more difficult than it needs to be because they want you to just throw your hands up like most people do, 90% or so, and not fight them. And then they make it that if you decide to defend yourself, you could look at what that means, what you need to do. And so people will weigh that out. Well, do I do it myself or do I go, do I get into debt for the rest of my life to pay a lawyer? They make it seem like it's a lot more difficult than it is. And it's not. Again, the difficulty is in dealing with these people who are gaslighting you, who are mocking you, who won't answer a simple question, and you want to pull your hair out. You want to strangle them. Like, we're adults. Treat me with some respect. You answer a question. And that's the thing. Lawyers don't answer questions. Lawyers are people. Look, they're the most hated, or one of the most hated professions out there. Universally hated for a reason. You can't get a straight answer from them on most questions. That's what I talked about in the last show.
A straight answer would be, well, actually, none of this applies to you. Go home and have a good day. We're sorry we bothered you.
That's one of the that's one of them. But other than trying to say to me, you're going to go, our laws apply, you're going to go to prison if when it comes to getting them to support their claims, that's when you can't get a straight answer. So that's what, we're going to be going up against the top of the hour break here in a moment. So find out more information. It sucks. It may be the only way to go in this situation, but at least when you call, ask them about the evidence-proven jurisdiction in your attempt to, find out what's going on and possibly enter a plea to make it go away.
Right, that makes sense. But my friend, he's quite frightened to go up against him at all, so...
Hey, they're criminals.
What can you do?
Yeah, they are criminals. I have said it from day one. They are criminals. And the proof is that they force everyone to pay them. They do everything under a force continuum. It's all by force. It's not persuasion. It's all by force. And that's why they're crooks. And we have to keep that in mind when we're dealing with them. And a lot of times, they just don't give a damn about what we have to say. They don't care the prosecution doesn't have the evidence. They'll defend them on the grounds that they don't have to prove it. They will lie, like with Patricia Starr. If you want, if you haven't heard last Wednesday's show, it's available now. Check it out. And I have the actual order, Patriot one. I have the order from Pat Starr herself, defending the denial of cross-examination. It's disgraceful. Absolutely disgraceful. Well, keep in touch, and I appreciate the call. Let me know what information you hear.
I will. Thank you, Mark.
I appreciate the call. My name is Mark Stevens. You're listening to the New State Project here on the Liberty Radio Network, LRN.FM. And please, I'm telling you, the Wednesday show, a lot of great stuff, and I have the pictures of the judges and the prosecutors that we are talking about there. So check it out, and we will be back with the second of 3 hours in just a moment. Yes, welcome back to the second hour of 3 hours of Anarchy Radio right here on the Liberty Radio Network. That's right, LRN.FM. We are live, if you're listening, on July 15th. And the number is 218-632-9399, 218-632-9399. The passcode is 2020. Well, you may join me on that there Skype at Frank Rizzo 3. Please send me an Insta message first. Remember, Jackalope is coming up in just a few weeks. 2 weeks, actually. July 31st through August 6th. Jackalope, Northeast Arizona. Northeast, about 2 hours drive from Phoenix. It's going to be beautiful. It always is. Always a good time to be around like-minded people. Anarchists, meaning they all reject the concept of a violent ruling class. And if you happen to disagree that there should be a violent ruling class, then, wow, I have yet to hear a valid argument to that end. I know. Who'll build my roads? I've heard them all before. All the excuses. None of them hold any water. So let's get back to that there Judge Kaczynski. And I have disparaged him before because he is a yes man on other issues where I've been involved with appeals that went before him, and there's no question. It doesn't matter how bad the trial court was. It doesn't matter that the witness was declared incompetent. Doesn't matter. When it comes to the IRS and a government attack like that, he's a yes man. But he's given it in the last few years. A number of times he's given it to prosecutors pretty good, which is really, really odd given his stance against the IRS. How he stands so tall with the IRS. So it's United States versus what is the? I think it's United States versus Olson, and I have the link and everything in the video we just released. And he doesn't really, he's pretty straightforward. If he was like this all the time, things would be different. Or they'd probably force him to retire, or they'd find child porn on his computer. You know how that goes. Anyone talks against the system, it's always child porn. The panel's ruling is not. Again, this is a dissenting opinion, and a number of other justices did join him on this, but this is a dissent. Now remember. Doesn't matter. It's still a federal judge saying this. And for a federal appellate judge to make statements like this, things are bad. Things are bad. I mean, to get under a judge's skin that they'll talk like this? The panel's ruling is not just wrong. It is dangerously broad, carrying far-reaching implications for the administration of criminal justice. It effectively announces that the prosecution need not produce exculpatory or impeaching evidence so long as it's possible the defendant would have been convicted anyway. This will send a clear signal to prosecutors that when a case is close, it's best to hide evidence helpful to the defense, as there will be a fair chance reviewing courts will look the other way, as happened here. Wow. A robust and rigorously enforced Brady rule is imperative because all the incentives prosecutors confront encourage them not to discover or disclose exculpatory evidence. Due to the nature of a Brady violation, it's highly unlikely wrongdoing will ever come to light in the first place. This creates a serious moral hazard for those prosecutors who are more interested in winning a conviction than serving justice. Yeah! What prosecutor is interested in justice? Seriously, I think I know one. And that's just what, wow. And I've, in what I do, I come across an awful lot of prosecutors. In the rare event that the suppressed evidence does surface, the consequences usually leave the prosecution no worse than had it complied with the Brady from the outset. Professional discipline is rare, and violations seldom give rise to liability for money damages. Criminal liability for causing an innocent man to lose decades of his life behind bars is practically unheard of. And he talks about the Texas prosecutor, reporting that Texas settled civil and criminal misconduct charges against former prosecutor Ken Anderson, whose suppression of evidence in a murder trial resulted in the defendant spending 25 years in prison in exchange for Anderson forfeiting his law license, serving up to 10 days in jail, paying a $500 fine, and performing 500 hours of community service. If the violation is found to be material, a standard that will almost never be met under the panel's construction, the prosecution gets a do-over, making it no worse off than had it disclosed the evidence in the first place. I'm going to continue here, but I want to restate something that's extremely important here. This piece of filth, this piece of human excrement, Ken Anderson, got less. He got less of a punishment than he would on a traffic proceeding. He knowingly put an innocent man in jail for 25 years. And this piece of garbage got less than a traffic offense. Don't anyone try to tell you there's no oligarchy in this country. Don't let anyone tell you there aren't two sets of rules. This guy would have gotten away with it. I agree with what's implied here by Judge Kaczynski that most of it will never come out. How do you actually prove collusion between the judge and the prosecutor? They don't always do it while they're in court on a cell phone like some of them have been caught doing. This is So again, criminal liability for causing an innocent man to lose decades of his life behind bars is practically unheard of, yes. But civil liability against the prosecutor from doing that is unheard of because they have absolute immunity even when they did it maliciously. Because former prosecutors gave them that immunity. Disgraceful. Olson's prosecution highlights the problem. The prosecutor did not take his constitutional duty to disclose exculpatory evidence very seriously. When do they? This is not the usual case where the prosecutor was unaware of exculpatory evidence being held by the police without his knowledge. The assistant U.S. attorney knew Melkonoff was being investigated and promised the district court that he would get more information, but never followed through. The record shows Elizabeth Brown, the state counterpart, repeatedly attempted to contact the assistant U.S. attorney concerning the Melnikoff investigation. On April 8th, she left a message asking him to call her regarding Melkonoff. She tried again on April 15th, this time providing the name and phone number of another state employee whom the assistant U.S. attorney could contact about the investigation. 10 weeks later, at a June 30th pretrial hearing, the assistant U.S. attorney promised the court that he would call the state. Good God. After months? Yeah, I promise. Lying. The judges should be throwing them in jail for lying, for contempt. Yeah, we ask a question, we go to jail for contempt. These people get up there and lie. Nothing. Acknowledging that he had not had a chance to call the state authorities, but will continue to pursue it. He stated, I know that I have to follow up and contact the state of Washington again, which I have done in the past, and every time I've contacted them, they've told me exactly what Mr. Trapedi told me. The assistant U.S. attorney didn't say whom he spoke to, but it wasn't Brown who was in charge of this aspect of the investigation. Is there any doubt that if the assistant U.S. attorney had thought Brown had inculpatory evidence to provide him, he would have managed to connect with her? Or if these messages had been from a doctor, from a broker, or a child school teacher? Well, I'm going to continue this when we get back. If you want to join me, it's 218-632-9399 with the passcode 2020. We'll be right back, so don't go away. Yes, welcome back to the No State Project here on LRN.FM. I'm Marc Stevens, author of Government Indicted, available at marcstevens.net. I'll get to the call, so just ask for your patience for just a few more minutes. This is I want to finish reading what Kaczynski wrote. Again, this is a federal judge in a dissent, U.S. versus Olson. But protecting the constitutional rights of the accused was not very high on this prosecutor's list of priorities. The fact that a constitutional mandate elicits less diligence from a government lawyer than one's daily errands signifies a systemic problem. Some prosecutors don't care about Brady because courts don't make them care. That's right, because the judges are former prosecutors. And why are they? And it's just a cycle that just keeps continuing. These prosecutors aren't held to that standard, so when they become judges, why the hell would they turn around and hold their own office to a standard that the judges never held them to? I wish I could say that the prosecutor's unprofessionalism here is the exception, that his propensity for shortcuts and indifference to his ethical and legal responsibilities is a rare blemish and source of embarrassment to an otherwise diligent and scrupulous corps of attorneys staffing prosecutors' offices across the country. But it wouldn't be true. Brady violations have reached epidemic proportions in recent years, and the federal and state reporters bear testament to this unsettling trend. I don't think it's a trend. It's always been that way, Kaczynski. When a public official behaves with such casual disregard for his constitutional obligations and the rights of the accused, it erodes the public's trust. I don't need the PR there. When such transgressions are acknowledged yet forgiven by courts, we endorse and invite their repetition, of course. And he gives an example of how bad this is. Just last month, Annie Dukin, a Massachusetts crime lab technician, was sentenced to 3 to 5 years imprisonment after spending several years filing positive results for samples she had not properly tested. Her misconduct tainted over 40,000 drug samples, implicating several thousand defendants, hundreds of whom have already been released. There's a case where they were noting a city investigation to confirm mishandling of evidence in at least 26 rape cases, prompting officials to explore over 800 more. Another case recounting the substandard work of a Texas lab technician affecting nearly 5,000 cases in 36 counties. Even the vaunted FBI laboratory at Quantico, Virginia, hasn't been immune from charges of falsification and pro-prosecution bias. They're getting paid by the prosecutor. Oh, yeah, they're getting paid for positive IDs. So there was something in the Washington Post, July 10, 2012, announcing that the FBI was undertaking the largest ever review of potential lab misconduct, over 10,000 cases going back to at least 1985 due to numerous problems with forensic analysis. It's how do rogue forensic scientists and other bad cops and prosecutors, I'm putting the prosecutor in, thrive in our criminal justice system? Because it's criminal at base. You're forcing people to pay you. The simple answer is that some prosecutors turn a blind eye to such misconduct because they're more interested in gaining a conviction than achieving a just result. No kidding. No kidding. You didn't seem to give a damn about that misconduct, Kaczynski, when we brought it to you again about the IRS and their attorney. Didn't mean anything to you. So while this is good, he's a hypocrite. Because if an IRS district counsel or IRS lawyer, from the prosecuting an IRS case, engages in gross misconduct, he just signs off on it. He couldn't care less. He is one of those that has allowed prosecutorial misconduct. Allowed it. He didn't send this message. We must send prosecutors a clear message. Betray Brady, give short shrift to Giglio, and you will lose your ill-gotten conviction. Unfortunately, the panel's decision sends the opposite message. The panel shrugs off an egregious Brady violation as immaterial. Had Melkinoff been fully impeached, the only evidence from which the prosecutor could have proven Walson's intent was to use ricin as a weapon would have been a few Google searches. On these facts, I would easily find a Brady violation, and of course he is the dissent, which is unfortunate. But the fact remains that all these Brady violations are part of the system, and they're not going to stop. You cannot hold them accountable. Yes, I still suggest that we file claims against the judges or prosecutors, the county or city insurance, the risk management. Yes. But even if you do get a settlement, the judge is not personally responsible. They couldn't give a damn. They don't care. How many times do we have to say that before it starts to say, they don't give a damn? So I love how George Carlin did that one routine. It's a big club, and you and I ain't in it. They don't give a damn. And even this Kaczynski, what he wrote, great stuff. He didn't follow through on that. I can tell you from personal experience, he overlooked Brady violations. Didn't give a damn because the IRS was involved. But let's get back to your calls. We have area code 201. What's your name? Where are you calling from?
Yes, hello?
Yeah.
Keith, how you doing?
I'm sorry, your name was Keith?
How you doing, Mr. Steve? Yes, sir. My name's Keith. How you doing, sir?
I'm doing well. Where are you calling from?
I'm calling from New Jersey.
New Jersey. All right. We haven't had a call from Jersey in a few weeks.
Yes, sir. I wanted to ask you, all right, I had caught a case
and I didn't know nothing about the law, and I ended up taking a deal. They changed. They was trying to give me 7 years with 40 to do 3.5, and they changed it over to a drug court program. So I was in this program for like 3 years, and I kept getting dirty urines for stuff I don't do. First of all, only reason I took it because I didn't know the law. Second of all, I like when I signed, I never got to read the thing because I'm blind. I'm legally blind. I told her when the public defender was like, well, read this. I said, I can't read this because I'm blind and everybody in the court knows this. He said, don't worry about it. Just sign it. My stupid mistake. So I did it. Now, I was on a program for about 3 years, and I kept getting dirty urines and going to jail. So one day I came back in, and they was like, you have a dirty urine. You got to go back in, and you might do 6 months, or we might send you downstate. Mr. Stevens, I said, okay, I got to go to the bathroom. And I walked out the court, and I haven't been back since. I just left. And I left 3 years ago, and I said, I'm not even trying to hear this. I didn't do anything wrong in the first place, and I got caught up in this charge just because I didn't know anything about the law, and I have money for a lawyer, anything like that. So what I wanted to know is there anything I can do? Now, the way this drug court works is if you go on the run or whatever and they catch you, they bring you back into the court, and then either you're reinstated on it or they sentence you to go downstate. So is it too late for me to do anything?
Well, it's not too late to do anything, but we're up against the break, so we'll explore this in the next segment. But it's going, the short answer is, it's going to be very, very, very difficult. But we'll discuss this. We'll talk about a solution when we get back. Don't worry. We'll be back in just a moment here on the No State Project. Yes, welcome back to the No State Project. I'm Marc Stevens, author of Government Indicted. Definitely please check out the latest edition after listening to the big show today. Episode 25, the commercial-free episode of the No State Project from Wednesday is uploaded, and I have pictures of all the criminals involved. So we got Patricia Starr, Daniel Magai, Ralph Beastline from Alaska, the scumbag who... Wow, I don't have the time to get into it now, maybe later. But Robert Wynn, who was the judge that convicted Ed a few days ago, and Gene Barrett, who was the initial prosecutor on the case that allowed it to get this far. Let it get to a conviction, knowing he didn't have any evidence, allowing it to continue. He knew it. He was the scumbag who, in the video from a couple months ago, that I did about, in fact, that's the other one with Patrick Starr, about the prosecution trying to flip the burden of proof. That even though he had no evidence whatsoever, he thought it was up to Ed to provide evidence to prove that he was wrong. So, filthy prosecution tactic. Don't fall for it. But we're talking now with Keith in New Jersey, and I can understand why you walked away. This is going to be it's going to be pretty tough. It may actually be one of those situations that may require you to get a mouthpiece. You might have to bite the bullet and get an attorney if you're able to do that. If not, you're going to have to do it all on paper. And my first thought would be to do a motion to quash the warrant for lack of evidence proving jurisdiction. So you challenge it, from the original assertion. And try to get that warrant heard on a telephonic hearing so that you don't have to walk in there and be arrested, because there most certainly is a warrant for your arrest, a felony warrant.
Yes. They have a felony warrant for walking out of court.
Yeah.
I have a case number. I called up to find out what's going on. See, the way I heard of you is from ethical anarchists. And I was talking. I ended up talking to him one day. Then I heard you on one of their shows, and y'all do basically the same thing. So I had wrote a letter to the prosecutor and the court, and basically stating that, telling them what they did to me. I know what they did to me now, and I'm not going for it. And I feel that that whole decision is void because you under coercion and duress, under the barrel of a gun. And what contract is good if you're doing it under the barrel of a gun? I didn't know what to do, and I just let them know that. And I took it from there just to leave a paper trail, because I knew I was going to have to handle this sooner or later. But I kept looking around, and other people, and then it all came down to you and Joe for Ethical Anarchists. And then I started listening to you, and you're just like amazing. The way you talk, I'm like, man, he makes it so simple. It's like you don't even need to know their terms. Like, the legalese or whatever it's called, and it's like you just talk to these people with. But I see how they do people, and they've been doing this. And I know nobody in New Jersey. I know a couple of people who you helped tried to do it. I heard a couple of tickets got dismissed, but I mean, up in the main cities and the urban areas, nobody knows about challenging jurisdiction and stuff like that. And I said, well, let me call in, and I just put money on my credit card. I have it set up so I can get ready. I wanted to pay to see if you could help me out with the 1 hour, how you pay to talk to you 1 hour.
Well, yeah, the consultation.
And, I have all that set up.
Yeah, well, and I don't want to leave anyone with the wrong impression. The tactic is very simple to understand and to implement. You do need to know some of the their legal jargon so that you can catch them when they're lying. I'm not saying that anybody needs to go to law school to get tickets and complaints or IRS stuff and drug. No, we've already proven that it's something you can learn in a short period of time. I would see when you sent them the letter. Let's say, how do I put it? You have to have a return address on there. So is it just to a P.O. box?
I have a return address. I have a friend who allows me to get mail at his address.
Okay, so so if they were looking to send a squad down to arrest you wherever you happen to be, they could. But all right, so I would go with the motion to quash the warrant and attack the original assertion of jurisdiction. And I would certainly be putting in there the ineffective counsel that they had you signing things that you're blind, you can't read, and they didn't even read it to you. They didn't see. Even if you read it yourself, the attorney's responsibility is to explain to you the legal ramifications of signing or not signing. That's part of their job. Their job is not to just sit there like an idiot and tell you to sign things. They're there to explain the ramifications so that you can make an informed decision. They even say when we go in there and challenge jurisdiction, go hire an attorney to explain it to you. Yeah, well, these are some of the things that they're supposed to explain. And they're not doing that. Telling you to just sign it and not explaining to you the legal ramifications, yeah, that's ineffective counsel. So I don't know off the top of my head right now if I would put the ineffective counsel. Yeah, I think I would put the ineffective counsel in there in top of as another reason to quash the warrant. And try to get it on, get it telephonic. I would put right in the motion, I am not going to subject myself to physical incarceration to be able to defend myself. And I am not going to allow you to force another attorney on me so that I can't defend myself effectively. But I can do it over the phone. And they do have the technology. It's not 1935, last time I checked.
Yeah, I understand. Okay. So am I able to still get the conference with you so we can you can help me out with this a lot? Because like I said, I can't see, and a lot of this stuff is going to be I got to get somebody to help me with.
Yeah, we can set that up off air and we can talk during the week. And I can use that we can use some of the time, of course, to get the paperwork ready. The motion to quash.
Okay, that sounds like a good idea. Mr. Stevens, thank you very much, and you will be getting a verification of my payment today.
And I appreciate the formality, but it's just Marc.
Thank you, Marc.
You're welcome, and
thank you, Marc. I appreciate it. All right, thank you.
Yeah, I appreciate the call, and we'll be in touch. We got Keith in New Jersey, where hey. It's bad in a lot of ways to walk away, but sometimes it's the only defense to don't let them physically take you into custody and then hold you prisoner. Man. All right. Well, we have a Skype caller. I don't know. But hi. Well, you're calling the Skype caller. You're live on the No State Project. What's your name? Where are you calling from?
Hey, Mark. How's it going? This is Imran.
Imran. And you're not in Arizona anymore, are you?
What's going on? Well, I'm technically right out of this moment traveling through some mountainous areas just northwest of Phoenix. So if the phone suddenly gets cut, it's not due to me.
Okay. Well, what's going on?
Hey, I remember when I called you a few weeks ago, we talked about that Bitcoin court case that's going on, and I was just wondering if you ever read the Arizona Republic a few days ago where they had this whole page on the doctor who is going to trial with Morpheus. And supposedly the trial is now set for August 1st, and I was wondering if you're going.
It depends on if I'm in Arizona or not, and I have a ride. It's depressing to know that he's been working with an attorney and not, and as far as I know, not making the challenges and the Brady request that I would think there was an effective way to go. And I'm not even aware of this doctor that's being charged, so I'll have to look it up. So we're up against the break, Imran, so you just hold tight. My name is Marc Stevens. We'll be back here on the No State Project in just a moment. Don't go away. Welcome back to the No State Project. I'm Marc Stevens, and we're talking with Imran. And Imran, where did you hear? Where was this story that you read about Tom's trial?
It was in the Arizona Republic. I've got the article saved, so if you want, I can fax and scan it and email it to you if you want. But basically, I was kind of right there when this happened. Basically, you remember that doctor that was made the news because he walked into Sky Harbor Airport with a rifle to assert his Second Amendment rights? Remember hearing that story?
No, I don't.
Okay, well, there's this doctor here in the Phoenix area, and he's big into like the Constitution and things like that. So he didn't like the way TSA was like, I guess, going Orwellian nowadays. So his assertion was the Second Amendment right to bear arms is being taken away by the TSA. So one day he walked into Sky Harbor Airport open carrying a rifle, and he got arrested for that. And I can't remember what happened. He got an attorney, and they made some type of plea, and so that was finished. I think he just had to do probation or something like that. And then he started getting involved into Bitcoin with Morpheus. And I think the DEA and some of these agencies, they don't like people to use Bitcoin. They want people to be slaves of the Federal Reserve notes. And so what they're doing, I think, is they're using informants to try and set up Bitcoin deals with people who use Bitcoins. And then what they're doing is they're having the people who meet these informants arrested, saying that you're transmitting money without a license, even though transmitting Bitcoin from one user to another isn't money. It's I think technically what you're doing is you're transmitting a computer code from one person using a phone app to another person using a phone app. But basically what happened is this doctor and Morpheus, I think they got caught up with some informant who wanted to do a $100,000 deal worth of Bitcoins. And the doctor went with Morpheus. From what the doctor told me is he didn't play any part of any deal or anything, but just by the fact that he was standing next to Morpheus during this, and I don't think actually any Bitcoin was traded or any money was traded, but just the fact that they were talking, they met this informant and was talking about doing this Bitcoin deal. What happened was, based on that, the informant gave the information to the DEA, and then I think the next day that led to the raid on Morpheus's place, and then the raid on the doctor's place. And of course, since they without any proof or evidence, they tried to tie this Bitcoin deal into drugs. They used the drug asset forfeiture rule, and they started seizing the doctor's computers. The doctor wasn't around at the time the raid was, and his wife and children were around. So the DEA kicked the wife and children out of their own home while they were getting like computers, laptops, and a safe, and seizing all this cash and things like that. So no due process there. But one thing, and this is kind of hearsay, if you want to, if you want the more, I guess, accurate record or whatever, I guess you'd have to look that up. But so the article came out about that in the Arizona Republic a week ago. I've got it, and I was going to say that if you're in town, if I'm in town, maybe I'll go to the trial. So I could give you a ride if you want to go.
Yeah, we might be able to do that. So yeah, stay in touch. Let me know. So it's Dr. Peter Steinmetz.
Yeah, that's him.
He's a neurologist. Yeah, he brought in 2014, brought an AR-15 into Sky Harbor to demonstrate what they're saying, the legal right to carry a firearm. And they're quoting him, I must protest a now nearly institutionalized attempt to intimidate us into surrendering our civil rights to other people's irrational fears. And it says the charges against him were dropped. And then they go, this is the AZ Central. I couldn't find the Republic one, but I it didn't look too long. But they're saying that there was a $107,000 or $107,000 worth transaction in Bitcoin that on the day that Tom was arrested, or Morpheus. Well, his name is out there. Everyone, it says that the jury trial is set. August 1st, like you said.
It doesn't say if it's in federal or county court. I'm assuming it's in federal court since the DEA was involved.
Well, they're being charged with operating. This is what the article says: 2 counts of illegally operating a money transmitting business without a proper license. So it could be state or federal, but it's more than likely it's federal. So if there is somebody who's listening that knows and can fill me in on that, maybe Dan is listening, can tell me. Here in the Valley, let me know. So, but yeah, if I'm in the Valley and I'm able to go, stay in touch with me off.
You know what'd be kind of interesting with this case is, they hired an attorney who's just gonna, I guess, block any jurisdictional concerns or anything like that. But what'd be interesting is if the attorney or if they challenge the definition of money, because Bitcoin is not money. It's actually a computer code or some computer source. And I was wondering if they would be willing to attack the definition of that, because technically even Federal Reserve notes aren't money if you want to be technical about it. I mean, in the Constitution, I think Article 1, Section 10, it says money is physical gold and silver. So they weren't transferring physical gold and silver; they were doing Bitcoin. So I was wondering if anyone's going to bring that up and challenge the definition of money as well.
I think that would be a losing proposition, because I think they have gone so far as to define Bitcoin as a type of currency or money. It's just not issued by a government, and it's not regulated like government currency would be. So I think that would be a loser. I think it's best to, again, strike the root, keep hitting them where they breathe, where, hey, you were there. For those who don't remember, Imran was there in person and saw Scott Bales, the Arizona Supreme Court Chief Justice, say that the evidence or the facts proving that the laws apply to us because we're physically in Arizona or the other people they put in prison. The best that they can do.
Well, violence, basically.
Yeah, but he, the sad thing is he's not even working. As far as I know, he's not working with Marc Victor, so he has got some chance. So I don't even know what kind of defense he's putting up.
You know what's interesting about that is originally Dr. Steinmetz had Marc Victor as his attorney, And then I don't know what happened because Steinmetz won't talk to me anymore. I guess because this whole case is going on, but he changed attorneys and has a different attorney. He originally had Victor and switched to somebody else.
I see. Again, I don't know. I don't know much of what's going on. I get very little information about it, and it's unfortunate. I mean, I've told other people this is what I can do. This is the way I would do it. But as long as he's got an attorney he's working with, then even if he agrees, the attorney has to agree to it.
Right. And I don't think any defense attorney would do that because then they would look at getting disbarred.
Well, there's certainly merit to I was saying there's certainly merit to that because an attorney I worked with did get disbarred, and all I'll say is that her name is Crystal, and she was disbarred from the tax court, and I know some would say, well, that's not real, but she was still disbarred. She's not able to practice in front of the tax court, and so a part of her business is gone. And she read me the riot act because once you get disbarred from one bar, then your home state, if you will, which for her was Colorado, then they could institute proceedings to have her disbarred, and so she could lose it there. So I wish I had more info, but we're at the top of the hour break. Did you want to stay on?
If you want me to, if you have other callers, I'll just leave.
Okay. Well, all right. Well, all right. Now I got all the calls, but I appreciate the call. My name's Marc Stevens, talking with Imran.
Okay, no problem.
And hopefully we get some more information and maybe be able to help Tom. But we'll be back with the third 3 hours of Anarchy Radio in just a moment, so don't go away. Yeah, the onion is really going downhill. Wow, that was bad. Just not funny at all. And I don't know. I'm Marc Stevens. Listen to the beginning of the third of 3 hours of Anarchy Radio right here on LRN.FM, where we are live most Saturdays from 4 to 7 Eastern Standard Time, 1 to 4 on the West Coast in Arizona, and Sunday morning if you're down under. And g'day if you are. Remember Jackalope? It's going to be starting in 2 weeks at Bacchus Meadow, Arizona. An hour and a half, 2 hours north of Phoenix. It is absolutely beautiful. You could just look up, get it on my website, markstevens.net, or go look up, you get the link. Or you could just do a search for Arizona Jackalope Fest, and it'll come up. I appreciate all the continued support of the big show so we can still keep doing it live. I do appreciate that. And hopefully real soon, maybe starting in August, we'll be doing the live Wednesday stream from my YouTube channel, so we're looking forward to that. But for the last article, we got that posted today. Apologize for the time that it took, but it is today, the last show. I got the pictures of the crooks that we're talking about, and of course the one I should have realized before I was doing a live broadcast, Patricia Starr, sitting as an appellate judge in Phoenix on a traffic case that came out of Chandler, Arizona, making an excuse, trying to justify the blatant denial of cross-examination. Not even trying to say that, what the judge did was wrong, but didn't rise to a level of being so wrong it would have changed the outcome of the case. No. Just lying. And about it, and then miscarry, and not even able to get. And when this was all pointed out, that the objection wasn't on point. It wasn't a proper objection. The question didn't call for legal conclusion. The question asked for facts the conclusion was based on. They're two separate things. But we've got other callers, so I'll continue with that. I got a caller on Skype. You're live on the No State Project. What's your name? Where you calling from? Just shout it out, who's ever on the line now. Okay, there we go. You're back. Hi, you're live on the No State Project. What's your name? Where you calling from? Well, we had some background noise, so... then they dropped off. Okay. So to get back, definitely check out that last show because really good stuff, especially tying into what we was talking about on the broadcast earlier about going into court and not looking stupid. That's a subjective thing. If they tease you and mock you, it's a tactic. It's not because what you're saying is stupid. It's because they are trying to cover up for their lack of evidence. So this is exactly what happened with this Patricia Starr, who is a judge in Phoenix. And yes, we had the pictures of all of them. I'm getting okay with the Photoshop. I was able to take the 2 pictures of those scumbags who helped convict Ed in Ohio. Robert Wynn, who was the judge, and Gene Barrett was the main prosecutor up into the trial. And so they both represent the state and yet proclaim that they're independent of each other. They're either just stark raving mad or they're criminals. And I think it's the latter. I think they're criminals. They know it's just vox et praeterea nihil. They know it's just their voice. They're just trying to justify it. So this denial of cross-examination, and this is very helpful for what we're talking about, is that they constantly mischaracterize the position in order. It's called straw manning. It's where you mischaracterize the question or the argument that somebody has in a way to avoid answering a question or to try to defeat an argument that's not as strong. And that's why a common one is we'll say that there's no evidence showing that the Constitution and Code apply. They will respond that arguing that you're not a taxpayer with the meaning of statute is frivolous. Of course, it's got nothing to do with the issue that we actually raised. So here with Patricia Starr, a very common thing. So what you'll do is you'll go in, let's say you're cross-examining a police officer, and you got to keep in mind here, the reason why you are in court, at least for traffic or drugs or taxes, is because somebody made a legal claim against you. They are making a legal conclusion / opinion or claim. And that is that the laws apply to you. You're physically in Arizona, and our magical rules apply. That's a legal opinion or a legal conclusion or a legal determination. And they want you to not question them on that. But what do you do when the police officer is on the stand? It's a cross-examination. What do when you're in court for an arraignment, let's say? What do you don't come out and make statements, for one. And I've been saying this on every show lately. You want to make sure that when you go in and you're defending yourself, that you are asking leading questions. And so you should not feel stupid by asking leading questions. Because at the very least, you're asking questions so that you're better informed, so you can make an informed and intelligent plea, which is what the rules require. It has to be voluntary and intelligent. So you shouldn't feel stupid, even if they're mocking you. Because if they had the proof, they'd just give it to you. They would remain professional enough to say, "Sir, ma'am, I understand you're not a litigator. You're not in court every day. You have a regular job. I get it. Those are pretty basic things, and they just explain it to you. But mocking you? That's not how professionals act. Just answer the damn question. Threatening you with contempt for asking questions? I mean, come on, really? You're going to pull somebody out of their life who's never been in court before, and they're going to ask a question? You think that's contemptible? See, in their mind, it is contemptible to ask them any questions that challenge their authority. That is where the contempt is coming in their eyes. How dare... It's like you have a parking ticket and you're challenging the application of the code to you? Because yes, when we go in there, whether we're doing it as damage control, because we're trying to limit the amount of damage these predators are trying to do, or we're there as an activist, you are playing by the same book, the same tactic. You're not just showing that the ticket itself is bogus. You're showing that the entire system that's attacking you is bogus and criminal. They aren't stupid. They know what you're doing. Hey, I plead guilty right now, jerky. Right now. Has the process, and this is your leading question, it's yes or no. Has the prosecution met their burden on jurisdiction? Yes or no? Where's the evidence? You shouldn't feel stupid asking that because you're asking for something the prosecutor is already required to do. It's no different than if you file against the judge or the prosecutor or against those animals at the IRS. They are required to have evidence of jurisdiction. The one who invokes the jurisdiction of the court has the burden of proving jurisdiction. And we're up against the break, so I will go into more detail about that. Yes, we're going to talk about jurisdiction again. And we will do so when we get back. If the number is 218-6... Well, we'll be right back. Yes, welcome back to the No State Project. Still looking for a open mic place in the East Valley to do the show once a week live with an audience. So if you are in the Valley, in East Valley, you know of a place. It's got a strong Wi-Fi. Let me know because I'd love to be able to start doing that. But till then, I'm hoping to get to Desert Eagle, which is a small, club, bar on Main Street in Mesa, right there downtown. And they have an open mic night, blues night, every other Tuesday. So this coming Tuesday, hopefully be there around 6 o'clock or so. Maybe get to play a few, couple of jams. So if you're in the area, check it out. I most likely will be there. If you want to join the big show, 218-632-9399. 218-632-9399. The passcode is 2020. And also Skype is Frank Rizzo 3. It's Frank Rizzo with the number 3. So, again, we're finding ourselves in court and wanting to have the confidence to go in there and not feel stupid because we are attacking verbally, questioning. When I say attack, it's in a legal sense, a collateral attack. All we're doing is challenging an argument. That's all we mean by that. It's not a physical attack like they're doing to us. So how do we look? You have to be confident in the material. You have to be confident that you're not going to be getting surprised and be getting answers from them that you're not expecting, that you not only not expect, but you don't know how to deal with it. And that's why the Socratic method is so important, because if you understand we're asking questions and clarifying questions and bringing out contradictions that way, by getting more and more specific about somebody's claim, someone's opinion, someone's argument. And it's very easy. You just realize it's who, what, where, when, why, and how. And when I do consultations with people, we'll do some role playing, and just to get the brain operating, or get you thinking right, to kind of go through scenarios and have all you have to do if we put something out, we hear a certain response. We'll look at the questions. There's only 6: who, what, where, when, why, and how. One of these is going to be appropriate to call them out on their BS. It's very easy. So there shouldn't be any surprises. And we could be very confident going in, knowing that they cannot, under any circumstances, they cannot prove their claim is true, that just because you're physically in Canada, their rules apply, or you're physically in Arizona, their rules apply. If you look at the trolls on my website, or rather more the YouTube channel, you're going to notice that they don't, the critics, the trolls, don't try to put out evidence. Their claim is laws are magical. They're not just rules written by men and women forcing us to pay them. No. They're magic, written by the hand of Odin himself. They're different. They will tell you that their rules are so special that no evidence is required to prove it. So you shouldn't feel stupid knowing this in advance, that they couldn't possibly make a case against you. They can't. They cannot prove jurisdiction, and they cannot prove that there's a valid case or controversy. They can't. Because they are just men and women forcing us to pay them. Those are the facts. Those are the facts that it is really virtually irrefutable. You cannot disprove that. No one can. You can have people like Harry Reid say paying taxes is voluntary, but that is, again, vox e praeterea nihil. It is just his dude, it's just like your opinion, man. Okay? It doesn't make reality go away. We have how many? It was Bill Montgomery, who's the county attorney here in Phoenix, and Scott Bales, the Chief Justice of the Arizona Supreme Court. The evidence, the proof that these laws apply because they put people in prison. It's all by force. So again, their rules can't possibly apply to us because it's all by force. They are forcing us to pay them. That does, so you may also hear, but they are applying it to you. How can you say it doesn't apply? It's if they try to apply the rules of the NBA to me. That's ridiculous. I'm not in the NBA. I've never signed a contract. I'm not a part of that. The rules don't apply to me. But they can still try to apply it and ruin my life anyway. But that doesn't mean that they apply. And it certainly is not evidence that they created an obligation on me to perform or not to perform. So you should be confident they cannot make their case. So then the next thing we have to work on is, how do I deal with all the verbal diarrhea? How do I deal with them sitting up there saying anything else? Anything else? I mean, seriously, I'll take a little detour here. I was so frustrated with this scumbag up in Minnesota by saying, look, if you ever had a case where the judge knew well in advance that that the IRS was going to win and you had no chance, that was it. This guy sat out there and literally most of what he said was anything else. And what do? How do you? So yes, a little detour was, just as a joke, well, what do you need to do in a situation like that? Do you need to pick up a chair and throw it towards the judge? Yes, you will be charged with attacking a federal judge. But guess what? The judge has to be called as a witness. That prick now has to be on the stand and has to explain what was going on. Why was he saying anything else? Why wasn't he responding? So you think, so to get back, we are thinking, what do we do in these situations where they're spewing verbal diarrhea? They're not answering the question. They're trying to gaslight me. I can't get a straight answer from these people. And that's where the Socratic method is great and the role-playing comes in. But through all of this, you have to come to the realization, all of us have to accept this. Some of us sooner than, going into court is not a game. Going into court sucks. I hate it. If I never set foot in court again for the rest of my life, I'll be a happy man. You are going against people who are criminals. They are willing to put us in jail for asking a question. We have proof of that on the site. Just asking a question. So keep that in mind. There should be some, not anxiety, but there should be a small amount of stress because you are dealing with these crooks. And even if you do everything right, that doesn't mean the judge is going to do the right thing. I mean, look what they're doing at this case in Chandler. Even the appellate judge is lying on behalf of the prosecutor. But still, more often than not, we get these things tossed out. And it's because we make it so difficult for them to make it look good. They just can't make it look like it's fair. But we'll be back in just a few moments here on the No State Project. Don't go away. Yes, welcome back to the big show. July 15th, we're live here at the Fortified Compound in Mesa, Arizona. Glad to be with you here. We're talking about trying to address things to people who are new to the material and the the natural subjective feeling of, well, feelings are subjective, of feeling stupid. How do you go in and effectively defend against this when, not feel stupid? Because you're challenging things that seem to be pretty well understood and established, and that you're going in and you are challenging these sacred cows. And we do that by knowing the material, knowing why we're taking the stance that we are. Why is it that we can be so confident they can't produce any evidence? Because there isn't any, because they're just men and women forcing us to pay them. And some may argue, but Marc, didn't society, and all of society is forced to pay them. No, they were never giving a choice. But Marc, people got to vote on the Constitution. It doesn't matter. People never were given a freely given choice as to whether there was going to be a government in the first place. The form of the government and choosing a figurehead doesn't change the fact that you are being forced to pay. And it's being forced to pay that's the Achilles heel. That's what defeats their arguments. This idea that the prosecutor is there as a valiant protector of the people. Give me a break. No one is voluntarily paying a salary. To hear what Kaczynski says about these prosecutors. On these facts, I would easily find a Brady violation. My only question is whether the assistant U.S. attorney's failure to disclose or discover the WSP report was willful or reckless, and if so, whether an order to show cause should be entered inquiring why he and his supervisor should not be sanctioned. Yeah. By turning a blind eye to this grave transgression, the panel has shirked its own duty and compounded the violence done to the Constitution by the assistant U.S. attorney. Yeah, well, you've done it yourself, too. You've been on those panels yourself, Kaczynski. And that's the thing, that nobody, you can give lip service to it. But these are the things that we're going to have to experience in court if we are going to defend against one of these attacks. And yes, to be effective and to be consistent, yes, you are challenging the entire system itself that is attacking you. Yes. Even for a parking ticket. Because, hey, Derek J. went in for a parking ticket in Keene and had Judge Burke lying through his teeth, jurisdiction's a trial issue, which is what I was going to discuss when we went to break. Jurisdiction. See, everything they say, this is part of the tactic. This is why you shouldn't have any surprises when you go in there. You should be assuming when you go into court that every single thing that they are saying to you is a lie, and you need to object and have them verify what they're saying. What if the judge says he's not there to answer questions? Really? You're not there to tell me what's in the record? You're not there to tell me if the prosecution has sufficient evidence for me to even be here? You arrogant prick, you. Think about that for a second. Think about just how arrogant and how cruel that is. I'm standing there willing to plead guilty if the prosecution has met their prima facie burden, which, yes, the prosecution does have a burden of proof. He bears the burden the entire time. And the arrogance. No, see, it's insult to injury. Not only has this black-robed criminal forced you to be there, now he's going to hamstring you into not being able to defend yourself effectively. Oh, how do I know? Because imagine doing the same thing the prosecutor's getting away with. That's why I say we always turn it about. If you want them to tell you how important their rules are, just try to get away with what the prosecution's doing. Go ahead. You'll get the same responses that I've gotten and other people have gotten. Ask them point blank if you can argue without evidence like the prosecutor. See what they tell you. And that's exactly what's going to be happening when you go into court, whether it's the arraignment or not. And jurisdiction has to be the first thing. It is called a threshold issue. Nothing is relevant except, I've said it 1,000 times, nothing is relevant until jurisdiction is proven. Sue them. They'll tell you that. You'll find out when they're the ones that are defendants. They'll never discuss the merits because they're smarter than that. They know better than to discuss the merits. They will never say whether they beat the living hell out of you or not. All they'll do is continue beating the same drum. There's no jurisdiction. There's no jurisdiction. Okay, so remember, we do the same damn thing. And that's where the lies come in. See, I was able to cut that crap out of the live broadcast on Wednesday. I didn't learn. So these things should at least minimize any feelings that you have of feeling stupid. Those who have proof of their claims just give you the proof. They don't argue they're not required to. They don't try to flip the burden of proof on you like Gene Barrett did, saying that they can argue and make claims without any evidence whatsoever, and you have to have the evidence. That's not fair. You know, everyone even new to the show, you should know already how to respond to that crap. No, objection! Don't you have the burden of proof? I don't have to prove that. That's not an element to the charge. That doesn't go directly to jurisdiction. You're saying you can make arguments against me without evidence? Yes. Objection. Do I get to do that too? No. Yeah. That sounds fair. That's why you have to laugh when you look at their shrines. You know, you look at their temples. And they had it on their temple down in Tempe. In Phoenix. Equality under the law. Yeah, right. That's why I say on the back of Adventures in Legal Land, is it possible that everything you think is real is just a public relations scheme? Yeah, well, when they say that is equal protection under the law, there you go. There you go. They can argue without evidence, and we can't. And so when and this goes whether you're on cross-examination or not. But when you're in a pretrial conference or you're at the arraignment, remember, the judge is acting as if the prosecution has already proven that the court has jurisdiction. And don't let them fool you here. The burden of proof on jurisdiction is not the judge's. The judge is only there to make a determination of jurisdiction based on the proof that the prosecutor has given them. He is not there to just determine on his own or sua sponte. Jurisdiction is a burden held by the prosecutor, not the defense and not the judge. And yes, they will snap at you. Regular listeners to the show, bear with me. I assure you, Mr. Stevens, this court has jurisdiction over you. Objection. Is that because you say so, or is that because the prosecution's evidence does? Leading question that eliminates the opportunity for this piece of garbage to go on to a narrative. Yeah, he can deny. He could just say nothing. He can just refuse. But keep the context in mind here. You're trying to plead guilty. You want to know if the prosecution has met their burden to this point. And he's not going to say what his determination of jurisdiction is based on? How can you defend against that? Oh, it's magical. The judge said so. Oh, well, we'll be back with the last segment here of the big show in just a moment. Don't go away. Yes, welcome back to the No State Project. Remember, we've got Jackalope coming up, so if you're not in Arizona, if you want to go, start making plans now. It's in 2 weeks, and it's always a good time. It's beautiful up there. Bacchus Meadow, 2 hours northeast of Phoenix. It's gorgeous up there. It's pine country, so I'm looking forward to that. I want to, again, thank everybody for their continued support of the big show. And I got a discussion going on the chat. It's good to see Terry back, who has some personal first-hand knowledge of things that the ugliness we've talked about on the show, where you can be held in contempt just for asking a question. The criminal Richard Noble, Dick Noble, up there in Michigan, known for that. Talking about prima facie, which is something we talked about a lot on last week's show, and we're going to just continue to keep talking about that because we get new people. Because, we have to know somewhat of their process so that we can call them on their BS. Yes, you should be assuming that's all BS, but it really does help to understand some of their process. And so, one of the things they'll say to you is they'll good cop you. You're willing to plead guilty right then and there if the prosecution has met their burden of proof on jurisdiction so far. And the judge will lie straight out. Well, it's a half-truth. They'll tell you you have every right to challenge the prosecution's evidence, but now at arraignment is not the time to do so. Jurisdiction's a trial issue only, and that's not true. Prima facie burden starts when he files that damn complaint. Prima facie is at first glance. It's if the factual allegations are accepted as true until proven otherwise, say at trial. Do they constitute a public offense? Do they constitute an actual violation of the law? Now here, like I mentioned before about a case, and we've mentioned earlier in the broadcast, they are accusing you of violating the law, which means they have to have proof that it applies to you. Proof. Is just an allegation the law was violated, and let's say that you don't have a driver's license, is that sufficient evidence to set forth an actual wrongdoing, an actual violation? It's not sufficient. In fact, I even read from the section in California, there has to be sufficient facts setting forth the violations. Facts. Just saying the law was violated is not sufficient factually to show that the law was, because you have to have evidence that the code was applicable in the first place. And they keep they want you and they want us to ignore that there has to be facts. And how many times it's still, I give you this, the trolls are slowing down on this. I think this is where we're getting some ground, guys. And I should do like a 2-minute video just on this particular issue alone. That I believe that I have not seen nearly the criticisms about jurisdiction being a pure issue of law anymore. And that's something you'll have to deal with at arraignment, or if you're at a pretrial. The prosecutor will actually lie to you saying that jurisdiction is a pure issue of law requiring no evidence at all. Zero. And yet, as we know, as it was reported by our friend Bill, the Twin Country Mountain Store, Desjardins he's a Superior Court judge in New Hampshire, contradicted himself. This is what happens. You keep asking questions, having them be more specific, and they just keep contradicting and lying. And this is the lie. Jurisdiction is a pure issue of law. No evidence is necessary at all. All the prosecution has to do is show that you're physically in New Hampshire. They just have to prove that you're here. You get that? And that's why I think maybe I'm not seeing nearly the criticism on that, which is actually a very welcome thing. Move on to valid criticism. Let's have an actual intellectual, process here. But to say that jurisdiction's a pure issue of law, even though it requires your physical location, come on. Come on. You shouldn't feel stupid going in because of what you're saying. If anything, you should feel stupid for having to be involved in the process at all. That the only reason why you're there is because they're threatening to put you in jail. Not because you're questioning them on this stuff. So this is one of the many lies. We talk about this all the time, but at least as far as the criticism, and not so much. Maybe the trolls are starting to, oh yeah, he's got us dead to rights there. That's an obvious contradiction. We have to stop saying jurisdiction's a pure issue of law because it's not. And the average person can see that if they have to show your physical location, that's fact. So it's not a pure issue of law. It's not theoretical. Oh, that's right, because Marc Stevens has been saying for how many years now, there's a difference between theoretical and practical. Once you involve somebody, it becomes practical. You need evidence. Holy crap. Aye. So, and the same goes when you're on cross-examination, which unfortunately cross-examination may be the only way you're going to get it tossed out. If they are that insistent on pushing you to trial, that they're ignoring everything, the cross-examination, if you do it properly by asking your leading questions, should be so devastating that it's impossible for them to make it look good, and they have to throw it out, or is going to be such a bad error that your chances are very good of having it tossed out on appeal. And so just like I discussed, and if you haven't seen the show, you haven't seen the video, check it. Well, I just posted it before the show. Check out the video. I've got all the pictures of the actors involved, the crooks, rather. And so I have a lot of the graphics with the actual citations so that you can read them for yourself and you can verify them. The cop or the tax agent or whatever bureaucrats are attacking you, they are absolutely making legal determinations. There is no way around it. Saying that somebody is not complying with the law is a legal opinion. It is a legal determination or a legal conclusion or legal claim. So-and-so broke the law. It's a legal conclusion. You're applying the law to a certain set of facts and coming up with a conclusion. Duh. It's in the name. Like territorial jurisdiction, it's in the name. Oh, I just noticed. For those who are just tuning in, I did post a brand new video today of Wednesday's live broadcast. So, Terry, check that out. Good stuff. We actually have a judge in Phoenix named Patricia Starr. So, the Patrick Starr references are right on point for that. But we're running pretty close to the end of the big show here. So, but definitely check out Wednesday's broadcast. I went to a lot of detail. But for now, I want to, again, and I'll keep repeating this. It's very important. It's very, very easy for you to get them to deny you an effective cross-examination. We're doing this purposely so the judge will either throw the ticket out right then and there, or he or she is going to commit an error that is so bad that you stand a greater than 50% chance of getting it tossed down on appeal. And watch the Wednesday video because I have the document in there. I'll get the PDF in the article for the podcast archive. But your first question is, did you determine on your own that just because I was physically in Arizona that your Constitution laws applied and that gave you jurisdiction to stop me? And so, well, yeah. That is a legal conclusion when they talk about probable cause. Legal conclusion! Anyone who says it's not a legal opinion or legal determination is lying to you. And then you follow up. What evidence? And that's when the prosecution screams, objection calls for legal conclusion. No, you lying snake. I asked for the facts. And you, anyway, we are completely out of time, but we will be live on Wednesday here on the No State Project. So till then, salud.